All right, the court is calling 2025 CR 007846 State versus Brian J. Warley. Could I have parties announced?
Jason Gary, head of the state, Your Honor. And Eric Rowland, I represent Mr. Warley.
And are you Mr. Warley?
Yes, ma'am.
And counsel, is your daughter here today?
He is, Your Honor.
Come up, please.
Yes, ma'am.
We're all mentors, and she's shadowing you, which is great. And I'm so sorry. What's your name?
For the record, this is Josephine Blair Barchetta DeWalt.
Hi. All right. Welcome.
Thank you.
All right. So, counsel, you received all discovery and reviewed it with your client?
Yes, Your Honor, to my satisfaction, yes.
All right. The court will find that the state is in compliance with discovery. Mr. Warley, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, sir.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor. Oh, I'm sorry, no. Apologize. We're waiving count one, proceeding on count two, Your Honor.
Any objection?
No objection, Your Honor. Thank you, Your Honor.
You're welcome. All right, Mr. Warley, did you review court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? All right. In count two, you're charged with possession of a controlled substance. Penalty group 1 to 4 grams. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Warley, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, the state is proceeding on count 2. Punishment is to be assessed at 8 years in the prison. There's a $2,000 fine. The state recommends community supervision. There's no application for deferred adjudication. There's to be restitution to the lab for testing of $60. TAP evaluation, follow recommendations, and no contact with the complaining witness. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, are there any such motions?
There was one motion that I'd like to address later, but no other motions, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 8 years. There'll be a TAP evaluation and 200 hours of community service restitution. Did you understand those were recommendations from the state and the court does not have to follow those recommendations? Then to count 2, how do you plead? Guilty, not guilty, or no contest? State any evidence?
Yes, Your Honor. State exhibit number 1 with all the statute. Your Honor, we've had an opportunity to go over that in its entirety. No objections to the minutes.
All right. Mr. Warley, did you review the waiver and consent to stipulation with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state will call in the right to remain silent.
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments and review the same. All right. After reviewing States Exhibits 1, just one moment. I'm sorry. All right. After reviewing States Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
I would hope so, Your Honor.
All right. There's something you said you wanted to address.
Yes, Your Honor. This is our first court hearing. My client has been very cooperative with me. My client was arrested on March 25th, 2025. and wasn't indicted until June 26, 2025, which was actually 93 days later. I submitted a writ for him to be released on a PR bond, but here I am in court, and the state made an offer that my client would like me to follow. He asked me, he understands sometimes you do a PSI, and we were wondering if we could proceed to sentencing. I would hope he would be granted from the bench and allowed to be done all these things while out of custody. He will abide by all conditions, and was just asking simply that.
All right. Who's your support system?
My family, my mother and my father, and then I have two roommates that I live with that are working for their parents that are working real estate, and as well as joining the church. So that is my goal is to get out of the environment that I was in, which this is out of that environment.
All right. And when's the last time you had employment?
Last time it was 2 years ago when I had lost my job at Citibank. It was a work from home job, and then unfortunately, things have happened, and I'm just looking forward to getting started working again, as well as my dad does own his own trucking company. And I was discussing with him the potential of actually helping him manage the books for him.
So not driving.
Not driving, no.
All right. Do you have any children?
No, I do not.
All right. So this is what the court is going to do. The court is going to sentence you to 8 years in the prison. Oh, and I'm sorry, State, you may be excused. Sentence you to 8 years in the prison, suspended and probated for 8 years. Regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 45 days. No employment as a home health care provider or with minors. No residing with minors. So when you were using, how often were you using?
I actually do not use drugs. I just was in the truck with drugs that were also in the vehicle. So I was charged with possession, but I do not use drugs. I've never failed a drug test ever in my life.
All right. We're going to do regular random UAs. No residing with minors. There's to be restitution to the Bexar County lab of $60. TAP evaluation out of custody. Follow recommendations. If you miss any of these appointments, a warrant's going to be issued. You understand?
I do understand.
There's to be 200 hours of community service restitution. And there's to be no contact with the following: Carlos Rene Fernandez, Celeste De Leon, Lucinda Anderson. Oh, they said that there were cards in the vehicle.
Oh,
okay.
Lucinda Anderson Richardson, Julia Ann Guerrero, Elijah Renee Velasquez, Matthew E. Cox, Jose Luis Nava, Aguinaldo, Layla Marquez, Michael Scott Torres with a Z, Samuel Garcia, Stephanie Marie Madrigal, Scott Smith, Mercy Trevino, Joseph Gutierrez, Jonathan Little, Jay Richard, Isabella Atchoe, Atchoe, Frederick Johnson III, Matthew Hune, David Lopez, Teresa Oliveras, and Jennifer Bianca. Field visits one time per month for 8 months. Probation, is there anything else?
On the names, Matthew, spell the last name, please.
Hune. Is there anything else you need from the court to be successful?
No, I've actually been while incarcerated. I've been taking classes and getting contact information for resources once I get released into society to where I can get IDs replaced, and also support systems as far as any type of like food stamps and different things like that, so I can sustain myself and move on.
All right.
So I do have some resources already provided to me.
All right. And with regards to that no contact, there's a restitution to those persons as well. Ms. Ferguson, if I can have a 45-day reset for a restitution hearing. All right. So September 22nd, you'll need to be here. That's to see if there's any restitution. If there's no restitution presented to the court, then there'll be no restitution ordered. All right. We can go off the record in this court. Communication is key when you're on probation. Speak with your probation officer. If you feel they're not addressing the issues you have, you can always come back to court. All right. Thank you.
Just to clarify, when you say come back to court, does that mean just like contact the courts or?
No, you're going to be given a setting and you need to appear in person. All right. And so you should be released from custody probably midnight. All right. And counsel, if there's an issue with this release, just come back to the court and let us know. All right. Thank you. Good luck. Yes, you may be excused.
And just
Yes, she may be excused.